constitutional authority to regulate the privacy of state-collected contact tracing data. Updated June 26, 2020. Amid the ongoing COVID-19 pandemic, several states have developed and promoted contact tracing mobile device apps to identify individuals who may have had contact with infected persons. Additionally, the two largest manufacturers of mobile device operating systems, Apple iOS and Google Android, have announced plans to release application programming interfaces (APIs) to enable interoperability between Android and iOS devices using apps from public health authorities. Several bills in the 116th Congress would regulate the privacy of information collected through such contact tracing apps. For a detailed comparison of these bills, see CRS Legal Sidebar LSB10501, Tracing Papers, a comparison of COVID-19 data privacy bills, by Jonathan M. Gaffney, S. 3663. The COVID-19 Consumer Data Protection Act of 2020 would 1. Require certain covered entities that collect contact tracing information to provide individuals with prior notice of such collection and the opportunity to opt into such collection. 2. Prohibit the use of such information for purposes unrelated to tracking the spread of COVID-19, and 3. Require covered entities to publicize their privacy and data security practices. S. 3749 and H.R. 6866, the Public Health Emergency Privacy Act (PHEPA) would prohibit certain entities from disclosing contact tracing information for purposes unrelated to public health. The bill would also prohibit such information from being used for commercial advertising or marketing purposes, or to discriminate against individuals with respect to goods, services, facilities, privileges, advantages, or places of accommodations. Covered entities include state governmental entities, although PHEPA specifically exempts public health authorities. S. 3861, the Exposure Notification Privacy Act (ENPA) requires operators of Automated Exposure Notification Systems (AENS) to limit enrollment in such systems to individuals who have provided affirmative express consent, to publicize the system's privacy policy, and to limit transfers of covered data to the minimum necessary to notify other users or a public health authority of potential exposures. ENPA also requires operators of an AENS to establish data security practices to protect the confidentiality, integrity, availability, and accessibility of covered data. In general, the bills above limit coverage to entities subject to the jurisdiction of the Federal Trade Commission or explicitly exempt state public health authorities. Nevertheless, during the debate surrounding this legislation, questions may arise over Congress's authority to regulate state governments' collection and dissemination of the relevant information. As context for that potential debate, this legal sidebar examines constitutional limitations on Congress's regulation of state activity, particularly in the context of applying federal privacy protections to state-held information. Federalism and the anti-commandeering doctrine. Unlike the state governments, which enjoy a general police power, the federal government is limited to those enumerated powers provided to it in the U.S. Constitution. One such power that is particularly relevant to the instant analysis is the Constitution's Commerce Clause, which allocates to Congress the power to regulate commerce with foreign nations, and among the several states, and with the Indian tribes. The Supreme Court has interpreted the Commerce Clause as authorizing Congress to regulate the channels of interstate commerce, persons or things in interstate commerce, and those activities that substantially affect interstate commerce. Legislation that falls within the bounds of the Commerce Clause may still be unconstitutional if it breaches the principles of federalism contained in the 10th Amendment, which provides that key powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Whether the 10th Amendment restricts Congress's authority to impose generally applicable regulations on the activities of states and their instrumentalities has been an ongoing debate since the latter half of the 20th century. Legal background. In 1974, the court decided National League of Cities v. Usury, holding that Congress may not use the Commerce Clause to dictate how essential decisions regarding the conduct of integral governmental functions are to be made. but the Supreme Court expressly overruled National League of Cities in its 1985 decision in Garcia v. San Antonio Metropolitan Transit Authority after efforts to define the scope of integral governmental functions proved both impracticable and doctrinally barren. On the other hand, following Garcia, the court held in two cases that Congress violates the 10th Amendment when it commandeers states to enact or administer a federal regulatory program. In New York v. United States, the court struck down a federal law that compelled states to provide for the disposal of the radioactive waste generated within their borders. Similarly, in Prince v. United States, the court invalidated a provision of federal law that required state and local law enforcement officers to conduct background checks on prospective handgun purchasers. Regulating state databases. After the New York and Prince decisions, the Supreme Court decided Reno v. Condon in 2000, a 10th Amendment challenge to the Driver's Privacy Protection Act (DPPA). The DPPA generally restricts the sale and disclosure of personal information held by state motor vehicle departments (DMVs) without an individual's consent. The DPPA also restricts the resale and redisclosure of driver's information by private parties who have obtained that information from a state DMV. After first holding that the Commerce Clause properly encompassed the sale or disclosure of such personally identifiable information as a thing in interstate commerce, the court found no 10th Amendment concerns with the federal statute. Distinguishing the DPPA from the statutes struck down in New York and Prince, the court held that the DPPA does not require the states in their sovereign capacity to regulate their own citizens. The DPPA regulates the states as the owners of databases. It does not require the South Carolina legislature to enact any laws or regulations, and it does not require state officials to assist in the enforcement of federal statutes regulating private individuals. We accordingly conclude that the DPPA is consistent with the constitutional principles enunciated in New York and Prince. Most recently, in 2018, the court's decision in Murphy v. National Collegiate Athletic Association reaffirmed the principle set forth in Reno that the anti-commandeering doctrine does not apply when Congress even-handedly regulates an activity in which both states and private actors engage. Analysis. Questions about Congress's authority to regulate the privacy of information collected by state public health departments through contact tracing apps are seemingly similar to those the Supreme Court addressed in Reno v. Condon. As noted above, the court in Reno first concluded that pieces of personal information collected by state DMVs were things in interstate commerce that fell within the Commerce Clause's scope. Under this reasoning, courts would likely consider the information collected by state public health departments through contact tracing apps to likewise be things in interstate commerce subject to federal regulation under the Commerce Clause. In addition, Reno appears to suggest that the 10th Amendment is generally not an obstacle to federal regulation of the sale and disclosure of personal information collected through contact tracing apps if such regulation is applied, even-handedly, to both state and private holders of this information. The rationale under which the Reno court upheld the DPPA's privacy requirements, that the statute does not require the states in their sovereign capacity to regulate their own citizens but merely regulates the states as the owners of databases, appears to be equally applicable to security and interoperability requirements imposed on public and private custodians of contact tracing data. Consequently, applying the court's reasoning in Reno, so long as such federal regulation of contact tracing apps applies even-handedly to both state and private actors, and does not also require states to enact legislation or refrain from enacting legislation, it would likely not raise constitutional issues under the 10th Amendment. Author information. Edward C. Liu, legislative attorney.